Good morning, everybody. Good morning. Good morning. Please be seated. Now, before you call the case, this is the first in-person argument this court has had in 6 months, maybe over 6 months, because we got flooded out in July. We didn't have full term in July. The last full term, I think, where we sat was June of 2023. So this is a special occasion. Glad to see you all here. Please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Housing Our Seniors in Vermont, Inc., the Agency of Commerce and Community Development, case number 23-AP-127. Representing the appellants, Housing Our Seniors in Vermont, Inc., and Lakemont Retirement Community, LLC, is Harold Stevens. Representing the appellee, the Agency of Commerce and Community Development, is David McLean. Representing appellee, City of Newport, is Bariah Smith. Representing appellee, Northeastern Vermont Development Association, is Daniel Long.
Okay, before we start, appellees, are you splitting up time? How are you handling that? Just let us know.
Yes, Your Honor, we are splitting time, 5 minutes apiece.
How many of you are there?
3 of us.
3 of you. Okay. All right, you're welcome to pull a chair up to the table if you like.
Okay. Thank you.
Yeah. Okay, Mr. Stevens, go ahead,
Good
please.
morning, Your Honors. May I proceed, Justice Ryder?
Please do, yeah.
Good to see you all in person again.
Thank you, you too.
I'm representing Housing Our Seniors of Vermont for the Lakemont Retirement Community, who own 12 acres of land in Newport Near the Lake with plans and permits to construct 160 units for seniors in Newport. And we're looking for a $750,000 grant from the Vermont Agency of Commerce and Development, which the funds came from this Kiros debacle for Jake Peak, so that they would have money for new business in Newport for the economy. And basically the Vermont Agency of Commerce paired up with this committee of these 3 defendants to select a project that would fulfill their requirements in their application letter.
Well, the funds for the grant that you're talking about came from out of a consent order in the federal court.
Yes, as I understand it, yes.
And were there certain terms about the bidding process that were included in that consent order?
I don't know what was in the consent order, but in the application to apply for the grant, it listed a number of 8 or 9 factors, which you've got a copy of the application, but there were a number of criteria to satisfy this committee that you were entitled to this grant. And my client met all the points for eligibility, and the business was owned by this lady named Heidi Eichenberg, who's an audiologist up in that area. And so she had borrowed money for the property. She was ready to go. She had building plans, and she went through this whole process as an applicant and basically didn't get her project funded. And
Stevens, this wasn't a bidding process. This wasn't like you put in a bid and high bidder or low bidder or whoever would get it. It was an application process, was it not?
yeah, it wasn't a bidding project. It was an eligibility project. Basically, they were looking for someone that was going to increase jobs, not only short term, but long term in the Newport community to get the economy going again. And so it wasn't a bidding process like you would for a highway or something like this. It was an eligibility criteria. And so basically, when she didn't get the grant and when this other applicant got it for over $1 million to do a project that we don't believe fit the bill for the eligibility. We brought an action for declaratory judgment to ask, at the time it was Judge Richardson, for a declaratory judgment as to whether or not these eligibility criteria were followed, that claiming that we had an interest in getting the grant, and that we were harmed by not getting the grant.
Can you show that if what you say the eligibility requirements were, and if they weren't followed, that your client would have received the funding?
Yeah, we believe so, and that's what we're.
What supports your belief?
Because we believe that we were like number 2 or number 3 on the list, but there's been no discovery because this was dismissed out of hand. We never got a chance to get to the bottom of it. So that's the problem. Judge Richardson goes, well, you don't have standing. There were no standards. There were no criteria. He cited the city fireman's case. Obviously, there were standards and criteria. And if there weren't, then it's an arbitrary process. And
Is there a statutory framework
Well, it's the,
applied here?
12, well, I mean, it's basically the Declaratory Judgments Act. It's the 12 VSA 4712. And that says that basically a court could determine controversies with people that are in a zone of interest and claim their interests have been affected. And clearly my client was in the zone of interest because she had her hat in the ring, and she was adversely affected because another operation that didn't fulfill these eligibility criteria got the grant.
I'm really worried that if you have standing, that there won't be opportunities like this in the future for committees to give out funding, because if everyone who applies has standing and doesn't get the funding, they can all take the committee to court every time they're declined some kind of funding. And wouldn't that impede this process of trying to disperse this money in a rational way?
Yes, it would if it was done in a rational way, but that's the problem here. We're saying this was done arbitrarily
Well,
and
that
without any standards, and that's a problem. And in those types of cases, you should have a right to complain. If it wasn't an arbitrary process, we wouldn't have a problem. But basically, the court ruled that there were no standards, and clearly there were standards. And we're just asking the court to look at what should have happened and what might happen in the future. And I think it's important that if you don't address these issues at the time they come up, then they're just going to go past. It's going to be unfair to people that are seeking these types of grants, and it's also unfair to the public because my client would have had possibly could have had 160 senior places up there, which you really need in the Newport area, with jobs for people to take, clean the rooms, maintain the buildings, and take care of the seniors.
What if the eligibility criteria you claim the successful applicant did not meet?
One, that they must be a business or not-for-profit entity within the city of Newport, the company that was from St. Johnsbury that got the funding.
But it says operating within, it doesn't say from.
Yeah, but they weren't operating. They weren't operating. They were looking at leasing a property and then renting it out. And then it wasn't a project that was ready to go. The other part was that primarily as soon as you got the money, that you would be hiring people and getting the project going. That was a big point so basically the main issue is they weren't a local company, and they weren't ready to, as we say, they weren't shovel ready. They weren't ready to go with this project. It was more of a leasing paper operation as opposed to providing any jobs for anybody. So I would just rest with that. If you don't have any other questions, have it in public time.
All right, thank you very much. Counsel for the appellee, please.
Good morning, Your Honors.
Good
David
morning.
McLean for the state of Vermont. Just a couple of points in follow-up. The plaintiff lacks standing in this matter because it has no legal interest in the outcome of this grant process. The grant money came from settlements in a state court case, state of Vermont versus Ariel Quiros and William Stenger in the Washington Civil Division. And in these settlement documents, the provision that puts the money into this development fund for Newport simply says, all proceeds from the sale of these properties shall be used to promote economic development in the Northeast Kingdom. That's it. And the court noted this in its opinion. The lower court noted that it's just a very simple, basic statement that that's the way this money shall be used.
But you supplemented that, didn't you, with the, I don't know what you call it, a flyer, whatever it was that you sent out to solicit applications?
Well, the state didn't supplement, but the committee that was created by the Agency of Commerce and Community Development did issue a letter of intent, which is attached to the plaintiff's exhibit as Exhibit 1, the Newport Development Fund letter of intent. And there are specific criteria, so to speak, on this letter of intent. However, the issue is that there's no legal framework around these criteria that would create a legally protected interest in the outcome of this grant. This was a discretionary process. So even if this court disagrees with the way that these criteria were interpreted by the committee distributing the funds, there's no legal basis on which this court could rest its opinion.
So does that mean no one can challenge what the committee did?
Given the facts of the plaintiff's allegation here, the plaintiff lacks standing. I'm not going to
Who
say.
has it? If they don't, who does?
So there may be situations where there are questions of discrimination that would give standing under the not discrimination laws in Vermont, or some other type of, if the money didn't go to economic development in Newport, then it wouldn't have followed the letter of the settlement agreements that said the money must go toward economic development in Newport. But under the facts of this case, there is no legal interest or legally protected right that the plaintiff has. They simply disagree with the outcome of the process.
But without discovery, Mr. McLean, don't they have a potential for looking at whether or not there's any inside dealing or any type of discrepancy within the process itself?
Well, so they do make an allegation that there was a conflict of interest on the committee in their complaint. However, there's no allegation that that conflict of interest had any influence on the outcome of the ultimate distribution of the money. So no, I don't think any discovery would have revealed anything. And even if there was a conflict of interest, number one, we're talking about Newport, Vermont. It's virtually impossible to avoid a conflict of interest when you're talking about organizations that are interested in community development. There are going to be members on multiple committees or organizations like this. So in the absence of allegations that it had any influence on the outcome of the distribution of the money, there's no need for discovery. In addition, you don't get to that point because there is no legally protected interest that was violated here. It was a discretionary process. There's no apparent self-dealing involved.
But isn't that what discovery might disclose? If the extent of that conflict, or if there is in fact a conflict?
Well, so I guess maybe, but even if there was self-dealing, then there's still no legal framework by which the court has jurisdiction. In cases that have evaluated this type of claim before, such as Wool versus Menard, where we're looking at the Department of Corrections taking bids for the provision of telephone services in correctional centers, I've taken up my 5 minutes. The other defendants have agreed that I can go for 7 if I need to. So if I can just finish this.
This is entirely in your collective hands. I hope you understand. We are not going to oversee your agreement. So whatever happens, happens.
Thank
That's
you.
our position.
Thank you. So just quickly, in Wool versus Menard, there was a statute that said the outcome of the bidding process needed to meet a specific criteria, which is that the phone services needed to be economic for the inmates. That gave the inmates standing. In the St. Albans case with the sheriffs, there was discretion, complete discretion in how they went about to contract with service to provide police protection. That is very on point here. There was complete discretion in terms of how the committee distributed the funds. So even if the court disagrees with how the committee interpreted this list of criteria in this letter of intent, there is no legal basis on which the court can rest its decision, and therefore no standing for the plaintiff. And I'll stop with that.
Thank you very much. Thanks. We'll hear from your co-counsel. If you would come on up to the podium, introduce yourself, please. Identify your client, and then go ahead.
Good morning, Your Honors. Mr. Chief Justice, and may it please the court, my name is Brian Cushman-Smith, and I represent the city of Newport.
Thank you.
The city of Newport should not be a party to this case. The appellant's complaint does not allege the city did any of the acts that the appellants complain of. In fact, the complaint only mentions the city twice. First, at Appellate Volume 100, paragraph 6, claiming the city is on the Newport Development Fund Grant Committee, which is odd to claim that the entire city is on this committee, but the complaint later clarifies at paragraph 17 that a representative from the city was appointed to this state committee. Simply appointing a representative from the city does not make a state committee, does not make the city responsible for what this committee does. In order to plead standing against the city, they need to allege that the city was the cause of their injury, which the city isn't clear on what exactly that injury is.
Did the city have a duty to make sure the application process was done appropriately?
This was not the city's funds, Your Honor. These were all state funds, won in a state lawsuit. The city has no duty here to any of the appellants. This is further clarified by what the appellant's requests for relief. None of the requests for relief would involve any act or enforcement by the city. For example, they asked for a declaratory judgment that the grant should have not been awarded to the Northeast Kingdom Development Commission. The city had no part in making that decision, aside from its city manager being on the committee appointed by the state. The second request for relief was that the Housing Our Seniors in Vermont application be reconsidered. Again, the city would not be reconsidering that application. That would be the state committee if the appellants were to prevail. And then disgorging over $1 million from NEKDC, the city doesn't have those funds. The city has no control over those funds. The city should not be a party to this case. There is no standing to sue the city for the unarticulated injury the appellants are alleging. Thank you.
Okay, thank you. Hear from third co-counsel, please. Introduce yourself.
Yes, Your Honor. My name is Daniel Long, counsel on behalf of Northeastern Vermont Development Association. And I join in the city of Newport's arguments as to none of the allegations against my client being actionable in and of themselves. But getting to the larger point here of the lack of any legal framework on which to base a claim, I think this case involves issues of standing and also issues of failure to state a claim. The overlap here is that the appellants haven't alleged any invasion of any law, any statutory right, any contractual right, any actual legal claim. They point to these eligibility standards, which they, in the briefing, call rules, but there's nothing about these eligibility standards that elevates them to a law under which a cause of action can be based. And in that sense, frankly, from a standing perspective, I'm not sure that appellant is any different than like a state employee who believes they should have gotten a state job and they were better qualified than another applicant, or a state college admissions process, an aggrieved applicant saying, no, this other person shouldn't have been admitted because I'm better qualified. Without the legal hook, there's no basis on which declaratory relief would be based.
So how's this process, what would be the process for policing this process of getting an application in and getting it approved?
I think that's a question for the legislature to answer. And I know in some of the secondary sources that appellants cited in their brief, they talk about like a low bidder process. But if you actually look at those cases, they all have a statute mandating that the winner of a bidding process be the lowest bidder, and they have standards put in place. So if the state is going to create more bounds for this type of process, then I think they need to do that through regulations or statutes, but that just wasn't the case here.
So they would have to be, the legislature fixed sort of similar to what the bidding, even though this is clearly not a bidding process here. This was an application process.
Right. Yeah. It's an application for funds. And in my understanding, there were multiple winners. I believe there were 3. It wasn't just one. And so.
Winners or recipients?
Recipients, excuse me. Yeah. So I don't think there's any basis, again, other than what counsel for the state was saying about if there's a discrimination claim or some other legal hook for this. I don't know that applicants can sue just because they thought they were better qualified than another applicant. And I have nothing further, Your Honors.
All right, thank you very much.
Thank you.
How much time is the appellant have, please?
Appellant has 6 minutes and 40 seconds remaining.
Counsel? So if there were 3 recipients of funds, you only sued one of them? Am I right?
Yeah, primarily for the reasons stated in our complaint. Again, we're appealing from a motion, a dismissal
Right,
of our complaint.
yeah.
And that is rarely granted. We maintain, we don't know whether or not the chief winner, Northeast Development Corporation, satisfied all the eligibility requirements. And I think we had a right to pursue that.
Mr. Stevens, what is it that you claim the city of Newport did or didn't do that gives rise to the cause of action on your behalf against them?
Well, with the city of Newport, we claim that their agent was on the committee, and that the city of Newport is responsible for their agent's conduct. The agent was representing the city of Newport on this committee. And this agent, Decker, we believe had a conflict of interest because he had interest with the other committee members. And that's the thing, we don't have a chance to discover that, but that's what we understand. And 2 is that if we don't have standing in this type of situation, I don't know who does. We clearly met all the criteria, which is whether you're a nonprofit entity, whether it's just not a feasibility study, you've got 10% equity, you've got the proper permits, you're ready to move forward with your project, you're ready to hire people, you're registered with the Secretary of State as a nonprofit and IRS as a nonprofit. And there was no disclosure as to whether or not the entity that received the grant met all those criteria. We don't believe that they did. And we weren't even given the opportunity to look into that. And again, what you look to is, as far as what standing is, we were certainly in a zone of interest. We were an applicant. We are a handout for the money. We had all the eligibility boxes checked.
So,
Yeah.
but isn't it discretionary with the committee at that point as to how the recipients or who the recipients are?
Yes, if they met all the criteria. So if you had 3 people that met all the eligibility criteria, certainly they have the discretionary ability to make that decision. But we're maintaining that, 1, there was a conflict of interest among the committee members. And 2 is that the recipient did not meet all of the eligibility requirements. And that was the complaint. And how are we gonna prove that without discovery? At least you let us get through discovery to see if those, in fact, doubts were in existence.
Does your complaint, I read it a few weeks ago, does your complaint indicate how, if in fact there was a conflict of interest, and if in fact the awardee didn't satisfy all the criteria, you would have been awarded?
Yeah, we believe so. that we
Well, you
would've-
believe so, but what evidence is there in your complaint to show that you would have received it, but for that?
That we met all these eligibility requirements. We ticked them off.
So everybody who applied, who had the eligibility requirements, all get the funding according to your argument?
No, that they get to select who, once you've met the eligibility requirements, I agree that they can just decide to distribute the money to whoever they want in their discretion. But our complaint is that their award of the grant was arbitrary because they didn't follow the eligibility standards, and in fact claimed there were no standards. So that's the big dispute here. Obviously, there were standards because they said if to be an applicant, you had to meet these criteria. And we're maintaining that the recipient of the grant didn't meet all those criteria, whereas we did. So we had an interest and we got hurt. In fact, my client's being foreclosed on right now. Thank you, guys.
Okay. Thank you both, or thank all for your arguments. Please call the conclusion of the hearing.
Next hearing for the court is scheduled for 9:15